Good morning, everyone. Welcome to the Infinity Fast Forward webinar series. My name's Steve Kessler, and I'm going to host the program today. We have a pretty important topic today. We're going to talk about the importance of hiring and retention standards and how that can impact your ability to be defendable against a lawsuit against your company. And we've got an expert that's going to talk to us about the importance of those areas. I think, we talk a lot about being defendable in lawsuits, and I don't think there's as much attention being paid to the hiring and retention process. So I'm very excited to get some details on how we need to be best buttoned up in that area to be defendable should that lawsuit come. So a couple of housekeeping items real quick. Everyone is muted that's joined the program, so we can't hear you. If you would like to communicate with us, you can use the chat box there and pose a question or make a comment there. You could also use the Q&A box if you choose to. We can see those on our side, and we'll try to take those questions that you may have probably toward the end of the presentation. In fact, why don't y'all just jump on the chat, tell us who you are, where you are, and who you're with, and that way we have some idea who's out there. And while you're doing that, I'm going to introduce our co-host, Mark Ray. Mark's joined us on most all of our webinars for quite a long time now. And Mark's a truck transportation executive, spent 35 plus years at a high level within trucking. Is a certified director of safety and does a lot of consulting work and works with various organizations to help improve this industry as best we can. So having said that, let me introduce our guest today. Our guest is Stephen Setliff. He's the founding partner of Setliff Law, which is based out in Virginia. Stephen is consistently recognized as one of America's best lawyers. Mr. Setliff represents clients in complex litigation at the trial and appellate level in state and federal courts across the United States. His multifaceted trial practice includes representation of clients across a broad array of industries with a focus on transportation companies, including trucking companies and railroads, in claims of traumatic injury by employees and non-employees. Stephen's trucking practice includes the representation of trucking companies, their insurers, and their drivers in a wide variety of claims, including catastrophic personal injury, property damage, and toxic cleanup. Steve also handles catastrophic workers' compensation claims, negotiating, drafting, and enforcement of commercial agreements, which includes brokerage and independent contractor agreements, construction matters, traffic citations, including felony charges, and employment claims under the Surface Transportation Assistance Act. His practice covers the gamut of trucking litigation from first scene accident investigation to effectively and efficiently trying cases to verdict. So, Stephen, having said that, I'm going to let you take it away.
Thank you very much, Steve. I appreciate it, and I appreciate everybody being with us today. I'm going to go ahead and blank myself out from the video, which should be a gift to everybody who is participating in this presentation today. So you only have to hear me. You don't have to look at me. I did notice in the bio picture that they included with my presentation, which was taken probably now 2 or 3 years ago, I'm wearing the exact same jacket, tie, and shirt. So there is some consistency in my approach to making sure that we're doing these things the right way. What I want to talk to you about today really is one of those things that you really need to get your head around and to make sure that you're understanding the importance of having your house in order when it comes to dealing with issues with respect to hiring and retention. And it really is one of those things that is focused on helping prevent the type of claims and getting ourselves in the best position possible to defend the kind of claims that we are seeing increasingly, particularly in the trucking industry. The failure to understand what's involved with hiring and retention can oftentimes be catastrophic and positioning yourself to be as well suited to defend these kind of claims is in fact critical. So let me talk to you a little bit before I start rolling through the slide deck about the world that we live in now as we defend trucking companies. The world that I've got cases right now for trucking companies across 33 states in the United States, at different stages of investigation or defense or being prepared or getting ready to go to trial. And I can tell you that what I see as I defend these cases, what I see as I try these cases, are some patterns that are emerging very distinctly, patterns that have actually emerged pretty distinctly over the last few years. First, let's talk just a little bit by way of background about how juries are treating us, trucking companies, commercial trucking companies across the United States. And the answer to that question, I often tease some of the guys in the office who help me put these presentations together that we should just put a slide up that says, it sucks. But the reason that it actually is as unfavorable as it is now really falls into three distinct categories. The first category is, of course, our friends at the plaintiff's bar. Our friends at the plaintiff's bar have gotten much, much better in identifying the appropriate cases and developing a story that they want to tell relative to the prosecution of those cases. The advertising that those guys are able to do, the limits that have been taken off of plaintiff's lawyers. If you look at advertising for plaintiff's lawyers across the United States now, it's ubiquitous. It's on television, it's in magazine ads, it's on billboards. And it's not just on billboards, it's on billboards in a way that is not just meant to get the identity of the plaintiff's firm out into the general public, but it's also typically conveyed in a way, particularly with respect to trucking companies, to convey a message that we're dangerous. There are a lot of advertisements out there on billboards, particularly that show trucks running into the side of cars, or just show the front of big trucks out there, all of which are meant to convey to a jury that we are dangerous, that there are things about us as trucking companies that juries should fear. Because from the very beginning, plaintiffs' lawyers, with their advertising, with the almost limitless type of things they can do now, want to start to plant in the mind of the general public, because that's where our jurors are going to come from, that we are dangerous. There are things about us that are dangerous. We are big, we weigh a lot, and we can cause a lot of damage when we get involved with accidents. That's first. The second thing that I see influencing the environment that we are in right now, candidly, is our jury pool and the people that end up serving on juries. I would say, at the risk of being slightly politically incorrect, what we are seeing in jury pools now is the sum total or the result of the last 30, 35 years of public education in the United States. There are a lot of people that serve on jury pools now, particularly in some of the areas where I try cases, where it would be a challenge for them, I think, to count to 10. So they are sometimes easily influenced. They're not as well positioned to critically analyze the evidence, and they bring with them prejudices and biases that have been formed in large part by some of the advertising that we see out there. Add to that a lot of the jurors that we see represent what I think is a general sentiment across the United States right now. People aren't happy. They're not in a good mood. There are a lot of people out there walking around who, again, at the risk of being politically incorrect, are pissed off about things. I often tell people when I do these type of presentations to try this little experiment if you don't believe me. The next time you are standing in a Wawa or Sheetz or a Buc-ee's or a 7-Eleven, wherever you get your morning coffee or wherever you get your gas, just look around at the crowd that is in there with you in the morning and see how many of the people that you see there in the morning appear to be in a good mood. If you see somebody that's smiling, your first reaction is probably going to be, damn, I think this guy's getting ready to shoot the place up. It's probably not going to be, oh, this person is happy or in a good mood. The general public, the people that serve as jurors, that are just not in a good place right now. And we can debate for hours why that's necessarily the case. Some people think it's because of a lack of substantial religion in our lives anymore. Other people think it's the way we are constantly force-fed bad news by the news media. Or other people think it's maybe because of other reasons. But whatever it is, we're dealing with a prospective jury pool in almost all places that have already been influenced by a substantial amount of plaintiffs' advertising calculated to depict us as dangerous, who aren't in a good mood. Those are the two things that contribute, at least the first two things that contribute to a lot of the results that we're seeing in the United States today. By the way, the results that we see in the United States today, which for commercial trucking companies on cases tried to verdict depending upon which statistic you look at and what you include or don't include. Cases tried to verdict now typically are coming in somewhere between $18 and $22 million. That's an existential event for everybody not named Walmart and Amazon. So if we look at those two things, we are left to ask, what is any other factor that's contributing to what we're seeing in courtrooms across the United States on cases against commercial carriers? And the answer that most people don't want to hear, but the answer that I think is probably most true, it's easy to blame the plaintiff's lawyers. It's easy to characterize them as the bloodsuckers that they are. It's easy to say, oh, how bad juries, nothing we can do about it. But the factor that I have found time after time that carries the most weight for why we are seeing the results that we see is us. It's the companies. It's the people operating the companies. It's not understanding exactly what the playing field looks like. It's not having in place the things that we need to have in place to be able to successfully anticipate and then successfully defend these cases. I'm not talking specifically about people intentionally doing bad things. I don't think there's very much of that left. There's some, and those cases are the ones that grab a lot of headlines, where a company will intentionally do something that they know they ought not to do. What really is more of the cause of it, candidly, is the failure to be educated on what the game plan that the plaintiff's lawyer wants to use against the trucking company. What's the game plan that they have rolled out and that they have found to be effective time after time against company after company? And I'm going to tell you what that game plan is. And I'm going to tell you what that game plan is, hopefully with an eye toward you critically analyzing how you do things. You critically analyzing, do you have in place the systems that you need to have in place to be able to successfully beat back one of these claims? Because if you don't, then you feed the narrative. The narrative is now and is going to be for the foreseeable future that we are a big, bad, dangerous entity, that we are a bad company, that we don't care about safety, that we don't care about how we do things. All we care about is moving a load of freight from one point to another point. Those are the storylines that the plaintiff's attorneys want to embrace. That's what they want a jury, who's already probably in a bad mood, to hear to render a verdict. So what is the playbook that they're going to use? Well, I'm going to talk specifically about two elements of the playbook today, but the four elements that the plaintiffs always want to focus on in no particular order are hiring, retention, training, and equipment. We're going to talk about the first two elements in just a moment. I'm going to give you just a little bit on the second two elements here at the beginning, and maybe mix some of those in as well. They always want to talk about training. They always want to talk about the fact that we haven't trained our employees appropriately, that our training, to the extent that we have it, is plug and play, that our training is not dynamic, that it isn't geared specifically to the equipment our employees are being asked to use, the jobs they're being asked to perform, the places they're being asked to perform them. That instead we put in a videotape, or we queue up a video for somebody to watch, or we have an annual safety meeting where we really don't focus specifically on how it is that we're doing things, or we don't focus on problems that we are having. So note to self, while I'm not going to get too deeply into the training topic today, because that's a subject for an entirely different presentation, your training should at minimum be dynamic. It should be geared toward what the job you're asking your guys to perform, where you're asking them to do it, and how you're asking them to do it. And if, to the extent that there are problems in job performance, then training needs to specifically address that and not hide from it. I would also add that relative to training, figuring out a way to shoehorn in as many different training experiences into an employee's life and job performance is a good idea. An annual safety meeting that lasts about an hour, that involves a bunch of guys standing around a fire pit, drinking sweet tea and eating fried chicken, is going to sound just like what it is to a jury who hears that. I would encourage you, relative to training, that you think about not only having your annual safety meeting, but that you also have some kind of quarterly events, and that you also try to do something on a monthly basis, even if it's nothing other than blasting out a rule of the month, or something on a weekly basis. A guy like me, to defend the company, to be able to controvert the bad company story, needs to be able to tell the story that we devoted substantial time and assets to our training program. It's one thing for me to say John has worked for me for 18 years, and in those 18 years, John has attended 16 annual safety meetings. It's another thing for me to be able to say that John has worked for me for 18 years, and during those 18 years, he has 427 different training encounters. The latter sounds a lot better and conveys to the jury that we are, in fact, invested in teaching our employees how to do the job correctly. The other thing
Hey,
that
Stephen,
yes,
I hate to interrupt you, but well, we're not seeing the slides on our side. Everybody's just seeing the introductory screen.
that's the only one. I haven't moved it yet.
Oh, okay. Would you move it so we can see if it's working? Because people are chatting in here.
All right, John.
Sorry to interrupt you, sir.
No, it's okay. No, you're good. Okay, keyboard I may have lost you. The other thing that I will mention briefly before I get into hiring and retention is equipment, and making sure that you have an appropriate equipment program that's in place, that when there's a complaint about your equipment, that complaint is logged, and that equipment is monitored and not passed back to service until that complaint is dealt with. Those are two of the four things that folks are going to want to come after you on. What are we here to talk about today? We're here to talk about negligent hiring and retention, and to talk about exactly why the bad guys like to come after negligent hiring and retention. So let's start with what constitutes a negligent hiring and retention claim and why the bad guys like to come after it. So a negligent hiring and retention claim is a claim that is separate from and different from the kind of claim that we think about typically associated with a truck casualty event. If John is driving a truck for me and John goes out and John gets into an accident, he hits somebody and arguably hurts somebody, and we get sued for it, most people typically think about the critical facts of the case being, well, did John do something wrong, or did the person that was involved in the accident do something wrong? Those facts indeed are important, but believe me, the good, competent, and capable and dangerous plaintiffs' lawyers are going to also want to include claims for negligent hiring and negligent retention. They want to include claims for negligent hiring and negligent retention because those create independent and separate bases for liability against the company. That means that creates something beyond just vicarious liability. Again, the vicarious liability is the idea that if John does something for me while John is working for me and in the scope of his employment with me, that I am liable for it as his employer. Negligent hiring and retention is a direct negligent action against the employer, regardless of whether or not that employee was in the scope of their employment. Why did the bad guys want to be able to do this? In addition to creating a direct cause of action, it opens up tremendous evidentiary considerations that would not otherwise be admissible in the context of a straight vicarious liability claim. For example, in a negligent hiring and retention claim, what's in John's background, his driving record, his criminal record, maybe his military record, his domestic relations record, everything in his employment record, anything in his background may be something that a plaintiff's lawyer is able to seize upon to be able to demonstrate that the company should have been on notice that it should not have hired John in the first place. It is a very powerful thing. And as you can imagine, a good plaintiff's lawyer will take the information in John's background and use that to further the narrative that the company that hired him is in fact a bad company. Because remember, that's the game, that we are a bad company and that we are dangerous and that we need to be punished. So if you understand that and understand where it's coming from, then you understand that the entirety of what they will go after is information that they can use to then argue that the company, when it made the decision to hire John, paid no heed to the risk of harm that he may cause for other people based upon the role that he was being asked to perform while at work. So what are the key elements? What are the things that the bad guys are going to want to prove? First, they're going to want to try to develop any kind of evidence that the employee exhibited a prior propensity for endangering others, that the employer knew about that, and that despite the employer knowing about that, or should have known about that, the employer hired that individual nonetheless, and assigned him to a position where he could reasonably create an unreasonable risk of harm to others. That's lawyer speak for meaning that John applied. There were things in John's background that I should have known rendered him unfit to work as a truck driver. But knowing that, or even if I should have known that through reasonable investigation, I nonetheless hired John and deployed John. And then John, in the course of the performance of his job, managed to go out and hurt somebody. That is pretty much the key elements that they look about. So what kind of things are going to be under intense scrutiny by the bad guys relative to this? They are going to scour the record to try to develop any of the things that you see, that there was some lack of relevant experience, that prior to being hired, that the individual wasn't suitably trained, that there was something in a driving record, including suspensions, revocations, or preventable accidents that should have put a prospective employer on notice of the unsuitability of this particular individual, that there were documented poor work habits or performance issues from previous employment, or that there is a criminal history that's relevant. And generally speaking, anything that the bad guys can find, they're going to find, and they're going to try to toss it against the wall to suggest that this particular employee was not suited for the job that he was tasked up for. One of the things that comes up quite frequently in the trucking context is, I know a lot of folks that we represent, a lot of folks in general, use independent contractors, owner-operators, to perform a lot of the work that they do. There was a time when using an independent contractor or an owner-operator would get you further away from a claim of negligent hiring and retention. But increasingly in jurisdictions across the United States, courts are starting to recognize the tort that is a cause of action for the hiring of an independent contractor. It sounds a whole lot like the hiring of an employee, the negligent hiring of an employee. Same kind of thing. Were there things in the independent contractor's background, for either from a lack of competence or lack of skill, that should have put a reasonable employer on notice that this contractor was dangerous, and that failure to recognize that resulted in harm to a potential plaintiff, and that the employer, the contractor, knew or should have known, the principal knew or should have known about the contractor's unsuitability. Simply stated, it's the same kind of action. And it's important to know in the places where you are operating motor vehicles, whether or not those states recognize the tort for the negligent hiring of an independent contractor. Because if they do, then utilizing owner-operators as a shield from negligent hiring liability will be utterly ineffective. So same kind of thing relative to the hiring of independent contractors it would be for an employer. It's making sure that you have done your due diligence with respect to the hiring of any type of independent contractor, and making sure that they are capable of doing the job that you are going to task them to do. So the other thing that people sometimes lose sight of in these cases is that there is a foreseeability nexus here. In other words, there typically is a nexus that says that whatever the individual's background was had to be, that the harm that ultimately was caused had to be foreseeable as a result of that background. There are some cases scattered around where you can find a court saying, going out on a limb, candidly, and saying that things in a driver's background did not reasonably put an employer on notice of foreseeable harm. There's a case here in Virginia, Interim Personnel versus Messer, where a driver had 2 DUI convictions, had failed to pay some fines, failed to attend counseling, had been declared a habitual offender. The court in that case ruled as a matter of law that did not reasonably put an employer on notice that an employee would eventually steal a truck, operate it for personal use outside of business hours, and cause an accident. I would suggest to you that is a pretty bold position for a court to stake out these days. You occasionally might find a federal court that will go that far, but generally speaking, most state courts, and indeed most federal courts now, will ultimately conclude that the question of foreseeability, that is whether the things in an employee's background made it foreseeable that they were going to cause somebody harm, is ultimately a question for the jury. So what kind of things, when I tell you to underscore the danger associated with these kind of cases, you don't have to look back very far to see the kinds of verdicts that are coming out on cases where there are bad facts regarding negligent hiring and retention. Here's a good one, or a pretty typical one that actually comes out of Illinois, where the driver's history had multiple accidents and license suspension, had been terminated from several other companies, and there was substantial discrepancies between the driver qualification file and the employment application. The driver nonetheless got hired. Individual gets in an accident, then gets hurt, pretty substantially hurt, and a jury returns a verdict for $35 million as a result of that, based upon the company's failure to do an adequate vetting of the driver and make sure that the driver complied with internal safety protocols. And then there is the, excuse me, I think I missed one here. Okay, no. So if you know that that's kind of the deal, that is going to be, that negligent hiring and retention are going to be one of the things that plaintiffs really come after. Let me make some suggestions to you, and I'm going to make several suggestions in the course of this presentation for you to think about. So first, before getting to the slide, think about the entirety of your hiring process. Think about how, if we have to document, if we have to lay out exactly what the process is step by step for you in front of a jury, what is that process going to look like? And let's start at the very beginning. What's your application look like? When is the last time you had your application vetted by your lawyer to make sure that your application is including all the things that you are permissibly allowed to ask in the jurisdiction where you're conducting the hire? That application should ask every single question that you're allowed to ask. Second, based on the information that's on your application, what are you doing to follow up on the information that you gather? If you're going to ask for prior employment and you're going to ask for references, if you're going to ask for criminal history, what are you doing to follow up on it? And importantly, what are you doing to document the following up of it? It's one thing to say, hey, we asked about John's driving record, and then we made some calls to prior employers, and the young lady out front, Susie, who handles making the calls, could never get anybody to call us back. But there's no piece of paper that references any of that in the file. If your efforts to document exactly what you did to follow up aren't recorded, aren't on pieces of paper, juries probably aren't going to believe them. So I would encourage you in the strongest terms, not just to make the calls about prior employment, not just to ask all the questions that you are legally permitted to ask and understanding what you're entitled to ask, but also documenting what you did. I'd also encourage you in the strongest terms to investigate fully any prior driving incidents or accidents, to get all the information about those that you possibly can. And also, as you were looking at things like employment, one of my favorite stories about this is a good buddy of mine who runs a company who had an employee who applied for a job that we ultimately hired and then got into an accident some years ago. And that guy had indicated on his employment application that he had worked as a barber at the Department of Corrections. And he had worked as a barber at the Department of Corrections as an inmate. And the whole inmate part had seemed to slip by us, and we didn't get that part. So making sure that we fully vet places of employment, when employment started, when employment stopped, if there are gaps of employment, why, and trying to get as much information during the vetting process as we possibly can. The general rule of thumb on this is, once a claim happens, if an accident occurs, anything that a plaintiff's lawyer can find, and they're pretty good at finding it through internet searches, social media searches, will be something that a court more times than not will suggest, or at least allow a jury to determine whether or not it was reasonable for us to have found it, and whether or not that should have put us on notice of an employee that was potentially dangerous. Other thing I would mention to you, I don't know who it is that conducts your hiring, or the people in your HR department who does it, but I would encourage you in strongest terms, whoever that person is, get them some training on an annual basis. Go through and be able to, you want to be in a position when the deposition that will come in these type of cases about whether or not we in fact were negligent about who we hired. One of the questions, if John does my hiring, one of the questions that's going to get asked is, well, what's John's training to do hiring? And if the answer is, well, John's done hiring around here for 10 years, that may not necessarily be enough. Certainly that's some experience, but it puts us in a much better position if we can actually go out and say, and once a year, John attends a Virginia Trucking Association or a Texas Trucking Association or a Maryland Motor Coach Association training session on hiring techniques and the things that need to be involved in the entirety of the HR process. I would recommend that highly. Probably the best place to start as you're thinking about defending these claims is being in a position where you can articulate what your standard is. How do you determine who it is safe and suitable for you to hire? And because that's something that in the context of a deposition, I almost always hear and see this question. What's your standard? How did you derive your standard? Has your standard for who you hire changed over the years? If your standard has changed, why has it changed? What input did you get from whom and when on how you derived your standard? And let me tell you, if your answer to what your standard is, well, we sent them to Great West or Bitco or Penn National or PMA or Travelers or whoever your insurer is, and they said they were okay, that's not a suitable answer. The company cannot delegate to a third party the responsibility of making a decision about whether or not an employee, particularly a driver, is safe and suitable to hire. The company needs to have its own standard. And the company standard needs to be something that's carefully thought out and been derived based upon multiple sources of input and something that becomes defensible. So as you sit and listen to me right now, you should be asking yourself, what is our standard? How did we get to the standard? And has it changed over the years? And what would my answers be to those questions in the event that I were asked those questions as a deposition? These are other things that you can see, some of which I've already talked about, but the interview process is critical, and having somebody who not only has done it before, but has been trained in interview techniques is absolutely critical. It's amazing what somebody who knows all the tricks of the trade with respect to conducting an interview can gather from an employee. You want whoever is conducting your interviews to be that person who, consistent with the legal obligations imposed during the HR process, can gather as much information as they possibly can. It needs to be somebody that does it over and over and over again, and somebody who's trained on how to do it. You need to, in my humble opinion, ask for references, and you need to follow up on those references. And there needs to be documentation that you followed up on those references. Again, not blank pieces of paper that are in the file. I would suggest to you to conduct robust background investigations. You can bet, a lot of people don't check social media. I encourage people to do so. I never hire a lawyer around here, or a paralegal or a secretary for that matter, without checking their social media. It's amazing the kind of things that you see that people will put on social media. I don't know why everybody feels like they have to tell me what they had for dinner last night. I don't really care about that. But what you sometimes will find, particularly with drivers, is they will put up things like videos of them rolling through Kansas City, shooting with their cell phone out their window as they roll down the road, which is probably a violation of about 42 different DOT regulations, as well as every safety regulation that you can think of. Or put up memes that say things like, if you cut off a truck, you're asking for an 80,000-pound suppository. There are things like that that people will put on their social media sites that will give you a clue about who it is that you're dealing with. So I would encourage you in the strongest terms to take a look at that. Also scrutinize employment gaps, because there's almost always a reason that there's a gap in employment for people, and get to the bottom. That will be a question during a deposition that you most assuredly will be asked, and be asked what you did to figure that out and what the answer to those questions are. If in your on your application, when you ask for driving records and criminal records, you need to investigate those. You need to know exactly what was involved and exactly what the disposition is. Lots of states, Virginia included now, has a full recitation of people's criminal history online. Not hard to do, and it's free. So I would encourage you to do that. Similarly, running people through, just running their name through the internet to see if they show up in any relevant news articles is also probably a good idea. There also needs to be some kind of process in place where you can say all of this information was looked at, and this is based on all that information, this is the decision we made. That doesn't mean 2, 3, 4 people have to be involved in the process. It just means that there needs to be a point in time that we can point to and say the information had been assimilated, it had been looked at, and that all of the things looked at led us to make the decision on this particular individual that we made. it's hard to underscore, you can't really do enough. Now, having said all that, I know that there are probably people on this phone call who do not have limitless resources to devote to that. And I understand that. Just know that the more you short sheet this process, the greater the risk is going to be that somebody somewhere, if this individual gets involved in an accident, is going to claim that you didn't do your due diligence with respect to the hiring of an employee. There are things I could tell people that were, there are 800 things probably I could say that if you really want to bulletproof your company and make sure that you're as immune from being sued as you possibly can. I understand that there's a financial component to all of that, but you've got to decide how much risk you're willing to on board. The less of these type of things that you do, the less follow-up you have, the more risk that you are onboarding, the more substantial risk that you're onboarding. A note, you would think in the world that we live in that compliance with the FMCSA regulations with respect to hiring, doing the things that we have to do, journal qualifications, make sure you take an application, looking for the MVRs, all this stuff, that would provide us with a shield, that it would allow us to say we did everything that the federal government said that we had to do relative to onboarding this employee, therefore we can't be liable for negligent hiring and retention. That's not true. As a matter of fact, the law across the United States is the minimum that you have to do is what the FMCSA regulations articulate. Whether or not you go past that is often a question, and whether or not it would be reasonable to go past that is a question that is typically left for the jury. Just know that compliance with the FMCSA regulations in and of themselves is not a get out of jail free card when it comes to the defense of a negligent hiring and retention claim. And to be put more point on that, the courts will still let plaintiffs, like claimants, pursue those type of claims even when the regulations have been met. And I would say, God help us if for whatever reason during the hiring process we did not meet one of those criteria, because failure to meet those criteria is sounding the death knell. Let's switch a little bit from hiring, because again, hiring is one of those things that you want to think about preemptively. Hiring is one of those things that you want to have in place before a claim ever happens. And let me also mention to you, the hiring process, when done correctly, can become a sword for a guy like me. Our drivers, God knows our drivers are going to make mistakes from time to time. And oftentimes I find myself in a situation where it's hard to defend the conduct of a driver. But I want to be able to defend the integrity of the company. I can defend the integrity of the company pretty well to keep a jury from getting mad at the company, but hopefully, and giving me a running start on defeating the bad company story if we pay particular attention to the hiring process. If I could say, look at everything we did. Look, we had our application that had been vetted. We'd asked for references. We asked for background. We asked for criminal history. We conducted social media searches. We did comprehensive interviews. Our guy who does interviews is the most trained interview guy in the Western Hemisphere. We did all of this to try to make sure we had hired the right guy. That's pretty good stuff. That's pretty good indication that we as a company care about how it is that we're doing business. Because I'm here to tell you that best defenses to these type of claims are, number one, don't have an accident, or number two, if you have an accident, run a company that a guy like me can stand up and say, not only are we not a bad company, we're a damn good company. We try to do things the right way. Look at the time, attention, and resources we pay to the hiring process. So understand, this is not just things that you need to do from a defensive posture. This is something that allows us to be aggressive when it is done correctly. That's all hiring. Retention is a little bit of a different deal, because retention now means that we have onboarded this process. And the claim that will come from the other side is, after onboarding this guy, even if his hiring was appropriate, and the situation they like to be in is to say you never should have hired him, and good God, after you hired him, you knew you should have gotten rid of him. But sometimes we're in a situation where, okay, he passed muster in the hiring process, but something occurred after he was employed, which nominally put us on notice that we shouldn't have retained him. And that's the real crux of that type of claim. It's the idea that the employee, once he was hired, once we had deployed this individual, did something that made it known to us, or should have made it known to us, that this employee was unfit for continuing in the job to which we had that employee tasked. And as a result of that unfitness, the plaintiff suffered reasonably foreseeable harm. So what kind of things are you going to see relative to that? What kind of things are going to get looked at? And this is where now I'm going to start this by saying the same thing to you here. What is your retention standard? Do you have one? If I could, of the 225 people on this call right now, if I could go right down the line and say, tell me your retention standard, tell me your retention standard, what would you say? And how would you handle the follow-up questions that, again, most assuredly are going to come in any type of deposition about this? How did you derive your retention standard? How long has this been your retention standard? Has your retention standard ever changed? If your retention standard has changed, why has it changed? Who had input on the retention standard? And just like with the hiring, the answer can't be, well, the insurance company continued to say it was okay for us to keep them on the policy. The company, you need to be able to articulate what your retention standard is, and you need to be able to articulate how you got to where it is that you are at present. So what are the things that you need to look at relative to retention and the things that can get you in trouble? What's the employee's work record look like since the time they have been with you? Are you getting complaints from other employees about this individual? Are you getting complaints from customers about this individual? Is there any incident of improper behavior? Typically job-related improper behavior, but if there are instances where there's substantial improper behavior off the job, you might get tarred with that as well. So things that could be reasonably brought to your attention about this employee on the job or off the job are things that you need to pay attention to. And what, if any, has there been any observation of improper behavior by managers and supervisors? So you can imagine the kind of things that, particularly in the trucking world, that you're going to need to be on top of. Monitoring of driver performance, particularly real-time monitoring of driver performance, driving records, and adherence to company policy. This one gets a little sticky sometimes, right? Because I know a lot of folks out in the world. John works for me, and John goes, John's been here for 4 years. He's never had a problem driving his vehicle on the job or off the job. We pull an MVR for John 1st of January. It looks good. The 2nd of January, John is somewhere in West Virginia after a Mountaineer game, gets drunk as hell, and gets a DUI. And John never tells me, and John never does anything to bring that to my attention. That creates a dangerous situation. So to the extent that you can be, and a lot of folks have access to, and a lot of folks use real-time monitoring, I would encourage you to use as much real-time monitoring as you possibly can. Saying that you had something in your handbook or your policy manual obligating John to tell me that he got a DUI sounds nice, but won't actually make that much of a difference if and when we get blistered as a result of that. So what is the foundation for dealing with negligent retention risk? Well, it starts with trying to hire the right people, right? That's where the two of these kind of interlock a little bit, is hiring the right people and making sure you've done your good interviews and your reference checks and your background investigation, that you're set for that. What are the other things that you want to do? We want to have in place systems that allow us to make sure that our drivers are complying with the FMCSA regulations, that we are monitoring them, that we are set up to get any kind of reports of any violations, that they are told that they're to bring those things to our attention, and hopefully that we have some kind of real-time monitoring. I would encourage you to make sure that relative to retention, you are having proactive training, training that is dynamic, training that deals with the job they're being asked to do, the place they're being asked to do it, the equipment they're asked to do it with. I would encourage you to have consistent and documented performance reviews, where if there is a problem with respect to performance, that it's not swept under the rug, that instead any type of problem is put up on the table and it's dealt with, and that if and to the extent there's remedial training necessary, coaching or counseling that's necessary, that happens, and that the company can show not only was it aware of the problem, but it dealt with the problem. Until whatever point that the recurrence of those problems violates your standard for retention, then you get rid of the guy. But making sure that you're doing reviews and that you're dealing with issues is important. A vigorous drug and alcohol testing program obviously is a cornerstone defense of this, and making sure that you are consistently enforcing policies, including disciplinary policies relative to all your employees. All of that is absolutely critical. Just like with hiring, you would think that complying with the standards on an annual basis that drivers have to comply with, pulling an annual driver record, getting medical and physical qualifications, having DQ files, all of that would inoculate the company. It will not. What that will do is provide the baseline that a company needs to comply with relative to retention, but a court will still let a negligent retention claim go forward. So, bottom line, be on top of what your employees are doing, however you need to do that. For folks who have cameras in trucks, and to the extent that they're not observational, some states have passed some observational headaches for us now that we're having to deal with it. I like random monitoring of driver performance. I like anytime that their camera in truck that and a driver has an issue that we deal with it. Whatever telemetrics that you're using those to monitor driver performance and to be on top of what it is that your drivers are doing. No, in the world that we live in, the only thing worse than not having some type of sophisticated technology to monitor driver performance is having it and not using it. So if you have it, use it. When you get an overspeed alert, or you get an unsafe turn alert, or you get any type of unsafe operational alert, do something about that. Don't just bury it in a file somewhere for some plaintiff's lawyer to find 3 or 4 years down the road and claim that you knew this guy was doing things like that and you didn't do anything to try to deal with it. Again, we've talked about training. Training for me, at every presentation I give, whether it's on hiring, retention, equipment, or whatever, training is one of those things that I believe you just can't do enough of. So making sure that you are continuously having dynamic training for your guys will go a long way toward helping us deal with retention things or retention issues. Other things I want you to think about, man, stay on top of your driving records, particularly in the hiring process, and certainly once you have gotten somebody on board, and make sure your standards kind of contemplate the kind of statistics that we see, which is drivers with clear records, amazingly enough, have a lower crash rate. I don't, not hard to figure out the link there, but having those kind of things baked into your standards is a wonderful thing to do. So just go beyond basic checks, thoroughly investigate driving records. I also encourage people to have extended probationary periods. My blood always runs a little cold when some of the folks that I represent, when I talk to them, that John showed up on Monday. Well, I interviewed him that morning. He filled out an application. We walked around the truck, and Monday afternoon he was on the job site with the truck. That just sounds bad. It sounds bad. John might have 25 years of driving experience, but it just sounds bad. People in this day and age, and again, think about your probationary periods and your initial training periods for what it's going to sound like to a jury. I want to be able to tell the story that John showed up, he came in, he filled out an application. We did our background check. We did our references. We checked his prior employment history. We checked the internet. We checked social media. We decided we're going to make John an offer. John comes back in. He does whatever drug and alcohol testing he needs to do. And then we spent some time. We went around. We showed John, this is the truck that you're going to be using, and walked him around and showed him all the operating characteristics of that truck. Let John get in the truck, and John rides with somebody for a day or two, or maybe even a week or two. And then John drives the truck and has somebody ride with him for a day or two or a week or two. Then John has the truck himself, and we have an opportunity to observe John operating the truck from various locations and using either our telemetrics or using our in-cab video. That's the kind of story that I want to be able to tell, and that's why I think extended probationary periods are good. That's why I think comprehensive road tests are good, to really see what a driver can do in a variety of different circumstances. And again, train, train, train. And to really help get ahead of the retention claims, make sure that anytime there is some type of event that has gotten your attention, that you're training specific to that event, some type of coaching or counseling to deal with it. If you do all these things, then you ought to not only see further inoculation with respect to hiring and retention claims, but you also should see some improvement in your CSA scores. Other things to think about, again, relative to the hiring and retention process, is making sure your maintenance program is good, you're mandating pre-trip inspections, and you're doing all you can do to cultivate an appropriate safety culture. And speaking of safety cultures, let me mention to you one of the things that I would encourage folks to do, especially with respect to hiring and retention. Call your lawyer, whoever does your work, your legal work, whoever that is, call them and get them to come talk to your drivers. Drivers, for as much sophistication that's on this phone call right now, and people who have been in and through the claims process, the lawsuit process, have dealt with things like this, I promise you, your drivers are largely ignorant of the way this works. They have no idea. All they know is what they see on TV. All they know about a courtroom is probably what they've seen watching Perry Mason or whatever the new lawyer shows are. Maybe I'm dating myself. Have somebody come talk to your drivers and train up your drivers about the kind of things that they could expect to encounter and how that's going to play out in a courtroom. And if whoever's doing your legal work doesn't want to do that, you might want to think about getting somebody else who wants to do your legal work. Part of this process also specific to hiring and retention is your handbook. Your handbook is going to be a feature of any negligent hiring and retention claim. So how's your handbook look like? When's the last time you updated your handbook? And I would tell folks on this call, if you don't have a handbook, bad on you. You should. It's 2025. If you need a template of a handbook and to get an idea of what it looks like, there'll be a code on this slide at the end. Send me an email. Just ask. I'll send you a template for free. I hate that word, but I will do it in the context of this presentation to help people get a running start on it. Your handbook can be a big shield on hiring and retention claims because, again, it's a way for me to take an articulation of what the company's values are and use it as a sword to say that we are trying to do things the right way. We hired these guys, and after they were hired, they got a handbook. This is what the handbook said. Even if the employee violated or did something wrong or broke some law or did something that caused an accident, the handbook provides a way for me to say, we are a good company. We are trying to do things the right way. I would encourage you relative to the handbook to pick a date once a year. This is the way I do it. I pick a date once a year where at lunch I sit down and have the very invigorating experience of reading my handbook because I want to make sure that my handbook still reflects the way that we do things around here, what our policies are, and what our procedures are. The only thing worse than not having a handbook is having a handbook that says you do things a certain way and then you don't do it that way. So a well-crafted handbook should be a compilation of your legal, your operating, and your safety folks, so that legal can tell you what you can do, operating can tell you how you are doing it, and your safety folks can tell you how you ought to be doing it. And that's what the handbook should reflect. You should look at it at least annually and make sure that it's up to date and that it's good. Again, it serves as a very powerful sword for us in the defense of these kind of cases, particularly retention cases. Other management practices for you to think about. Again, you want to constantly be operating or analyzing your operational measures. The metrics, I should say, your crash rates, fuel mileage, off-road miles, overall operating costs, making on-road observations to have a way to see how your guys are doing things, using your telematics, and again, using them, really digesting the information that you're getting to effectively monitor driver training. Having automated triggers is a good idea, and you might even want to consider speed management. Those things can help, are all helpful relative to retention in the defense of retention claims. Let me also suggest to you along the same lines, one of the things that can be immensely helpful relative to the defense of hiring and retention claims is having a third party come in and just take a look at how you do things. And a lot of people will use their insurer for this. I am more wed to the idea of whoever your lawyer is, whoever's going to defend you on these kind of claims, or whoever you've got a relationship with, to come in and sit down and walk through with you. How are you doing your hiring process? What does your retention process look like? What does your training program look like? What does your equipment repair, maintenance, and inspection program look like? And this, based on how you're currently doing it, this is how it's going to play out in court. This is what it's going to look like. These are things that you need to understand what the risk is with the way you're doing things, whether that's astronomical or de minimis. And these are things that you may want to consider changing relative to any of that. Doing that once every year or two is a very cheap insurance policy to make sure that you are, again, as inoculated as you can be for these type of cases. I've talked some about the internal review process, but making sure you're monitoring your drivers, having the appropriate disciplinary framework for retention is all very critical. That's tied up in the idea of having an articulable standard of how it is that you're going to retain folks and having in place an appropriate penalty structure, however, whatever that penalty is going to be. Again, I'm a coaching and counseling guy when somebody steps out of line. So I like to coach and counsel right up to the time that we discharge somebody. Um, I'm sure it comes as no mystery to anybody that just like with hiring cases, retention cases can be catastrophic for failing to pay attention to some of the details that I've mentioned to you. There are two cases that I would point out to you so you can kind of get a flavor for that. One is the Denton case. This is a company that really didn't do much of onboarding with respect to once a driver was hired, no real training up front. And then within just a few years of application, multiple accidents, multiple moving violations, a whole bunch of issues that had happened. And the company there got hit for $54 million. Probably the mother of all negligent retention cases is the AJD case that came out of the great free state of Florida. That involved the driver. It caused a two-vehicle accident that ultimately resulted in the death of an 18-year-old college student. And the facts in this case are just awful. The kind of things that the driver had been doing, that lack of background investigation, including inability to read English, and just the multitude of moving violations and incidents that this driver had been involved with. Long story short, the jury in that case returned a verdict for $1 billion, a billion with a B. That's the kind of thing that can happen if you don't pay attention to the details here. You heard me say at the beginning that the real reason that the bad guys want to pursue these kind of claims is because it opens up a much broader evidentiary scope. And in English, what that means is if there are things in John's background that don't sound particularly good, they want the jury to hear all of it. They want the jury to hear about all the prior moving violations, all the accidents, all the problems with prior employment, maybe being dishonorably discharged. Who knows? Whatever it is in somebody's background that could help paint John, my driver, in a bad light. They want to get that in front of the jury so that the jury thinks that John's a bad guy to help them ultimately further their narrative, their tail end narrative, which is the company is a bad company, because you know who hires bad guys? Bad companies. And that's exactly the story that they want to tell, and that's why they want to go after it. Other thing to mention is negligent hiring and retention claims, because they are independent basis for liability, can trigger punitive damages. They can provide a separate and independent basis for punitive damages. So even if the underlying facts of the accident itself were not necessarily reckless or wanton, if during the hiring process, the plaintiff's attorney is able to demonstrate that there was sufficient recklessness or lack of attention to detail in the hiring process, that could trigger an independent basis for punitive damages in and of itself. It is a lot to take in, and it is something that, John, now you guys have to go back to the camera. But it's something that has become part of the new game plan, or at least the game plan has been utilized at least for the last 10 years by plaintiffs' lawyers in the handling of these cases. I will say again what I said at the beginning, to get yourself as well positioned. And what I usually, the image I try to leave folks with this, particularly the hiring or the retention claim, is this. Whoever your HR person is, they're sitting and whatever the process is, as the decision is getting made as whether or not we're going to hire John to be a driver for us, I want you to think about putting that decision on a piece of paper and standing up in front of a jury, wherever it is that you operate commercial vehicles, and asking yourself whether or not you're comfortable with what that decision is. If you're getting clinch factor associated with that decision, that probably tells you about all you need to know. Similarly with retention, as you make retention decisions, putting that retention decision up on a piece of paper and standing up in front of a jury. Are you good with it? Are you comfortable with it? Can we defend it? Or is it one of those things, as a trial lawyer, I will tell you, almost anytime I go into a situation where I know I have to start explaining things, I know I'm starting behind the 8 ball. So if either of those decisions are going to put you in a position where you've got to start immediately from the outset of the case explaining things, then you may want to rethink it. That's what I've got for you. If you have any questions, I'll be happy to answer.
Great, Steve. Thank you all very much. There are a lot of requests for the handbook template that you mentioned. So we'll have we've tracked who's asked for that, and we'll make sure you get that list, Steve, so you can send those out.
Okay.
One thing I want to say is one of your at the very beginning you talked about the four big things, the core things, and one of those is training. And I'm going to pop up a little poll question here. We have with Steve put together what we call the Ultimate Defense Video Series. This is some premium content that you can use. There is actually, I think, 25 videos altogether. There's one general introductory video. There are 14 that are designed for company employees and 10 that go out to the drivers. And this is all about accident procedures, evidence, things that the drivers need to do and not do at the scene of an accident. And also for the company employees, it's all about making sure you've done those four big things and done them correctly. Talks about the handbook, drug and alcohol testing, training, an accident checklist. And by the way, this product also comes with the access to a digital checklist, one that the company can use to make sure that they're doing all the right steps before, during, and after a crash. And the same thing, one for a driver to go through the steps necessary at the scene of a crash. So I'm asking any of you out there if you'd like a demo of this video series to answer yes to the poll, and we'll make sure we get back with you and give you all the details. Also, I see several of you have noticed that if you're a certified director of safety under the NATME program, we can send you out the certificate to make sure that you can get your recertification points from having attended the webinar. And before everybody else gets off, I have one question myself. You talked about performance reviews as being important with the drivers. Is there any danger in some of the information that you might put there that would be discoverable by a plaintiff lawyer? In other words, don't say things like, well, you almost killed somebody today or something like that. Is that dangerous? How should things like that be worded?
Uh, yes, that's dangerous. Training, when we talk about when we talk about training, it's not just. I always talk about training in multitude of contexts. Training that occurs before the time an accident happens. That's first. Second, it's training at the time that an accident happens, and third, training after the time that an accident happens. That is knowing what to do, what to say, and how to say it. So all supervisory employees should probably have some kind of training, not to do things like write stuff like that in performance reviews. It should be specific enough to indicate that we had addressed a particular problem, but not specific enough to suggest that there was some horrific or overriding danger associated with it. Just like people should be trained. I've had a couple of very good clients I've had to work with to correct things like John goes out, and I'm just picking on John today because he's with me, but John goes out and gets in an accident, and the first thing I write to one of my partners is I knew John was a dumbass. It was only a matter of time before he was going to hurt somebody.
Yeah.
So it's one of the things I really try to underscore in the world we live in. Having a relationship with your lawyer, who can help you with what needs to happen with how's your training supposed to look like with respect to things like coaching and counseling employees. What are you supposed to do at the time of an accident, and what are you supposed to do after the time an accident happens? Those things are not intuitive. They're not. And understanding how all that can play out in the context of the lawsuit is critically important.
Great. One last question, and we're a little over our time, but there's a question here from Dominic. He's saying, I wanted to ask about something I recently observed. Shortly after an accident occurred, several attorneys began reaching out, offering their legal services to the individuals involved. almost immediately after that incident. This happened so quickly that it raised some questions. How is it that attorneys are able to get the contact information of parties involved so quickly after an accident? Are they also contacting the other party in the case? I'm trying to understand how the process works and whether this kind of outreach is standard or regulated in any way.
So I'm assuming the outreach was to the nominally injured potential claimant types. Yeah.
That'd
So
be my guess. Yeah.
yeah, well, one of the good plaintiffs' law firms monitor police scanners. They monitor police scanners for the occurrence of having of an accident. Some perhaps less than reputable law firms actually have relationships of some sort with folks who provide emergency services, either law enforcement or EMTs, where they'll just get a call, hey, heads up, there's been an accident, so and so, and they can get the names of it. I will tell you that I probably investigate, me and my guys probably investigate, I don't know, 70, 80 crashes a year. And I would bet you a full 20 to 30% of those, the bad guys know about them before I do. Before I can, but by the time it takes my company to call either me or to call the insurer, who then calls me, the bad guys already know about it.
They already know.
So again, knowing what to do and how to deal with this stuff is critically important.
Very good. Steve, if there are any more questions popped up that we didn't get to, I'll make sure I forward those on to you so you can reply if necessary, or you can send these to me. Everybody should have my email, was on all the invites.
All right,
But Steve, thank you, sir. This was great information. There have been a lot of requests for the recording of this webinar so it can be passed on to other folks. I hope you all took the time to scan the QR codes there so you can get more information about Steve and his firm. Great information. I think it's going to be an eye opener to a lot of companies out there that there's a lot of detail here. I think a lot of companies think they have this all kind of buttoned up, but it has to be pretty granular, doesn't it?
It does, extraordinarily so.
Absolutely. Very good. We'll send a recording link out to everybody that registered or attended so you can share it with others. Steve, once again, thank you, sir. Great information. Thanks to everybody that joined us today. Mark, thank you. And we hope to see you all on our next webinar. Once again, thank you, sir. Thank you, Steve.